So yesterday, FINRA filed a response to Rosa's motion for reconsideration because basically Rosa said, "Hey, Judge, you done fucked up. You ruled on something that actually has precedent that's the opposite. I need you to look at this again with this information and see that you screwed up, and you should reconsider and look at possibly issuing this injunction again." FINRA filed a response. We're going to read those today. And the response basically says, you can't do anything to us. We're more powerful than God. They also filed a motion to dismiss. So they are asking the judge to dismiss everything. Just throw the whole thing out. Because, again, FINRA's claims are more powerful than God. So we're going to read through those, and I don't know how long it's going to take. It's like 30 pages worth of stuff, so it might take a little while to get through it all. But, you know, such is life, right? Monkey, why are you whining? What? You're doing your little breathy whine thing. It's weird. It's weird. You want a blanket? Will that help? All right, whatever. Okay, so... if you're throwing questions at me, I'm not gonna be able to answer them right now, just so you know. You guys can have your little chats there. But we're going to read through the filings, which I got all queued up for once. So this is the which one is this? This is motion opposition. So it's 15 pages or so. Okay. If you remember, in Rosa's filing, she points out a few things. One, they had claimed that she didn't prove any harm. So Rosa went, "Hey, you promised me 1-for-1. I can't get 1-for-1 because of all these naked shares and unclosed shorts that exist. And you not forcing the closure in your corporate action of these shares and then allowing them to go through the settlement period and potentially be offered this 1-for-1 NextBridge shares that harm me. Plus, I can also be harmed because the company may dilute their stock and I didn't have the opportunity to get out before they did it." And then we saw the filing this week on Monday of for 40 million more shares to be issued. So the dilution is happening. So she pointed out those two things and then pointed out that FINRA didn't care about settlement when the original MMATA shares were issued, the original preferred shares in 2021. They let it trade for 5 more days after the date of record, and they did not care then about settlement. So why all of a sudden do they care about settlement now? So those are kind of the key points. And she showed not only is there proof that there's synthetics and counterfeits out there in short shares, she did so via their own website. And then she took a legal case from their own website showing that they not only can be sued, but they can be forced to reveal the accounting on if there are short shares or not. So she was very smart in that the data she used was from FINRA's own website. Okay. All right. So right off the bat, we got plaintiff's motion for reconsideration. The FINRA's opposition to plaintiff's motion for reconsideration. Basically, FINRA says, no, you can't do that. So here they talk about how if you're going to do a motion for reconsideration is an extraordinary relief that does not operate to provide a party with a second bite at the apple. So basically they said on January 9th, 2023, the court properly denied plaintiff's motion. So they're saying when the court said, no, you can't get an injunctive relief or TRO because FINRA is immune. The FINRA lawyer, of course, saying like, yes, they are. We are. You can't do anything to us. We are special little boys. And they said, based on the plaintiff failed to meet the requirements of obtaining preliminary injunctive relief, and that she failed to address FINRA's possible immunity. She did address FINRA's possible immunity. She stated specifically she was seeking injunctive relief and not monetary damages because FINRA is immune from monetary damages, but not injunctive relief. That is settled case law. Rule 59 may be used only on 2 grounds. 1, newly discovered evidence, or 2, manifest errors of law or fact. They address 1 in this, but they don't address 2, which she pointed out several times. While plaintiff claims to offer newly discovered evidence in support of the motion, none of that purported evidence provides any basis for this court to reconsider its decision. I mean, that's a bold statement for not actually addressing anything. Plaintiff also spends the majority of motion disputing the legal arguments FINRA made in the opposition to plaintiff's motion for a temporary restraining order. Absent an allegation on the January 9th order contains manifest errors of law or fact, the motion amounts to a request that the court revisit its decision. An impermissible use of Rule 59, plaintiff's motion for reconsideration must be denied. Okay, here's the thing. Absent allegation that the order contains manifest errors of law or fact, that is in her motion. She showed that the FINRA lawyers misrepresented court precedent saying they couldn't be sued, when in fact in the case they had been successfully sued and forced by the court to do an injunctive relief. They also misrepresented the 2 laws at play here, which is the Sherman Act and the what's the other one? We'll get to it. Anyway, so she shows that there was errors. Those the central thesis to her entire motion is that there were errors of fact and law. So them just saying she didn't show that at all is them not doing their job. They're doing a little double speak here. They're going to try and gaslight the judge and tell the judge that he isn't seeing what he's seeing. It's kind of a little lawyer trick. Okay. Moreover, the reason stated in the FINRA motion dismissed plaintiff's claims are barred by immunity as matter of law. No, they're not. Because in her motion, she cites specific examples where FINRA does not have immunity. So now they're trying to claim immunity to everything, even though in their original filing, it was only immunity to monetary damages. Okay. Argument, reconsideration pursuant to Rule 59 is extraordinary remedy within the sound discretion of the court. Basically, the court has the discretion to go, you know what, we messed up. We're going to look at it again and redo this thing. Just saying that they're complaining that the motion seeks to amend the January 9th order, but that's the entire reason why she did it. The motion, however, fails to provide basis for requested relief. Does it, though? I mean, she literally provides the basis for requested relief for the motion, saying, I've been injured, others have been injured, and we will continue to be injured until this is rectified. That's the basis for requested relief, right? That we're keep being injured, and the law that FINRA cited that they can't be sued and forced to obey an injunctive relief is erroneous. Like, does not apply to them in this situation. So, more doublespeak. All right. A, absolute immunity precludes reconsideration. The court's January 9th order properly denied the emergency motions because plaintiff failed to satisfy her burden, demonstrating that such relief was appropriate in this case. She showed it. The court never acknowledged it. That's a difference. She talked about there being short shares in existence on this private company. Therefore, she could not be guaranteed her 1-to-1 offering of the NextBridge shares. So that is the entire point that they have never addressed. They have not addressed short sales on the MMTLP stock, and they won't address them in this filing either. Okay. In her complaint, plaintiff summarily concludes, without furnishing any factual support, not true, that when FINRA halted trading on the Series A shares, it prevented the reconciliation of short positions held by market makers and brokers at the expense of shareholders. She used the data from their own website that showed short shares existed. Not just any short shares existed, that like 29% of the float was at least shorted. From their own website. Their own website says, hey, Betty, we haven't closed any of these things yet. So when they state without furnishing any factual support, she literally puts the website where you can find it from FINRA's own documentation. All right. So FINRA lying through their teeth right here. Okay. FINRA's decision to halt trading and quoting on Series A shares was a quintessential regulatory function. So they claim. But Rosa showed the last time they should have done that, they didn't do it. When Metamaterial and Torchlight merged, the date of record, glonk, was one date in June, and then they continued to trade the Torchlight shares for 5 more days, screwing up any possibility of having, sound settlement procedures for this untradeable Series A preferred share. So FINRA, right here, saying that it was a quintessential regulatory function. If it was so quintessential to the regulatory function, why didn't they ever do it before with any stock that is having date of record happen? Right? If it's so quintessential, then why have they never done this before? Quintessential assumes that this is like a normal thing. Like this is what we do, man. Like if you got some sort of data record coming up, we gotta stop trading you because how we settle. I don't know. It's not how we do that. I don't know the way you've done it every single solitary time you've ever had a date of settlement and continued trading afterwards. Maybe, I don't know. Like that's kind of how it works. Okay. There are a few functions more quintessentially regulatory than suspension of trading. Okay, the suspension of trading that they're citing here, Merrill Lynch and Pierce Fenner versus Manning, they're talking about like circuit breakers, right? Talking about corporate fraud, other forms of fraud, Ponzi's, you name it, manipulation, pump and dumps. That is different than taking a stock that's trading normally and going, you can't trade anymore. They actually have regulatory function on those things because there's legal malfeasance happening. There was no legal malfeasance happening in trying to close the MMTLP shares before the company went private. That's how you're supposed to do it. That's what's supposed to happen. The brokers had already said that they were going to go to position close only and force closure of these short positions, meaning no new positions would be created. Therefore, it would not affect settlement when it came to the distribution of these NextBridge shares. So FINRA they're doing lots of legal doublespeak here, using things that don't necessarily apply to this situation and pretending like it's totally normal. It's not. You've done a U3 halt on domestic stocks 3 times in your history. That doesn't seem normal. Of the 2 other times, one was because 2 insiders of the company were suing each other, and FINRA's like, we're going to stop trading until you guys resolve this. The other time was a company that was going to do a 100-to-1 reverse split and then immediately do a 10-to-1 forward split. And FINRA's like, why don't you just do one 10-to-1 reverse split? Why are you doing all this other crap, right? So those are the other instances where they've done halts like this on U.S. stocks. The other times on other stocks are like crazy Chinese companies owned by warlords and drug dealers, Ponzi schemes. Those are just like straight up criminal fraud cases. So here they're stating like, it's totally normal when there's extraordinary circumstances like we claim for there to be, a halt. No, that's not true at all. That's not how it works. You guys know it. You're lying through your teeth right now. Okay, because the trading halt was in furtherance of FINRA's statutory delegated authority to regulate the securities markets, absolute immunity bars plaintiffs' claims. But in the plaintiff's claims, she showed that every time you've made a decision like this, it's benefited the hedge funds and hurt the retail investors. Not only that, she showed that in arbitration, you put your thumb on the scale to the benefit of Wells Fargo, to the detriment of whoever Wells Fargo was up against in arbitration. So you have a history of A, lying, and B, not doing your job properly and using your powers for evil, basically. So the FINRA dudes are playing fast and loose with the truth here. All right, assuming this court grants FINRA's motion to dismiss, the court need not analyze whether the plaintiff established basis of this court to reconsider the January 9th. They're like, oh, you can just dismiss this whole thing and you don't have to worry about any of these legal arguments. Further, because absolute immunity bars plaintiff's claims, they don't have absolute immunity. They have immunity to monetary damages. That's first and foremost. Their claimed absolute immunity does not exist. They do not have absolute immunity. A plaintiff cannot establish a likelihood of success in the merits support request for preliminary injunctive relief. She already pointed out that you guys have had cases where they've ruled injunctive relief against you. So she's right and you're wrong. Without showing a likelihood of success in the merits, a party is not entitled to a preliminary injunction, and the court need not consider the preliminary injunction factors. Okay, but she did have merits. So you guys, there's one thing that really pisses me off about this filing, is that Rosa laid out the argument in very succinct ways, described what was happening in a way that a child should be able to understand it. And here, they're just gaslighting the judge, saying she never showed any of this stuff. No, she did. Repeatedly. Again and again. She has 240 pages of it, right? That she's shown over and 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 over, right? Okay. So they're doing a lot of doublespeak and a lot of gaslighting of the judge, basically saying you didn't see what you thought you saw. You saw nothing at all. And they're trying to Jedi mind trick him. There's no basis for consideration of Rule 59. Only two grounds support Rule 59, motion for reconsideration, newly discovered evidence, which she showed, or manifest errors of law or fact, which she also showed. While a motion purports to present newly discovered evidence, none of the cited evidence would necessitate a modification to the January 9th order. Except they said she couldn't prove she was harmed, and then she provided evidence that showed she was harmed. She did exactly what FINRA asked her to do. Your Honor, she didn't show unequivocally that she was harmed. And she says, no, I was harmed. This is how I was harmed. This is from your own website. And FINRA's now saying she didn't show any evidence. She did. She showed evidence. So quit gaslighting us. Okay. Further, because the motion does not assert involves manifest errors of law or fact, plaintiffs have to dispute the TRO opposition order's proper request that the court re-examine unfavorable ruling. She did show that there was errors of law or fact, because FINRA cited laws that don't say what they claim they say, and FINRA cited court cases where FINRA was successfully sued, but said the opposite. So in this right here, again, they're gaslighting, and they're showing that she didn't do these things, even though she clearly laid out in her last filing all the legal precedent, all the times that FINRA has been wrong and sued and had injunctive relief imposed upon them. And so she's able to show, yes, there's new evidence, and yes, that there's errors in facts or law. So FINRA's gaslighting the judge again. Okay. Newly discovered evidence identified by plaintiff does not warrant reconsideration. Okay, so here, all right. The paragraph above, right, basically says that there's no newly discovered evidence, and then they there is newly discovered evidence, but it's not enough to reconsider. So they gaslight the judge and say there is no newly discovered evidence, and then they make the argument that yes, there is newly discovered evidence, it just isn't that important, right? So they're gaslighting and then doubling down by minimizing the thing that they gaslighted about. This is truly, I get the feeling this entire thing was written by a different person than the first response, because it is written better, and it seems way more manipulative than the last one. The last one was just like, they can't do anything. We're all powerful. This one is like playing with language in a way to make you question reality, and it seems like a much more evil and smarter person may have written this. Okay. Plaintiff's motion claims that it uses newly discovered evidence to support the request for consideration. When seeking relief from judgment based on newly discovered evidence, the party seeking relief must show: 1. The evidence was newly discovered after the court ruling. The movement exercised due diligence in discovering new evidence. The new evidence is not merely cumulative or impeaching, and the new evidence is material. And 5. The new evidence is such that production of it earlier would likely have changed the outcome of the case. Okay. Again, remember, their entire premise was Rosa didn't show she was harmed. So Rosa provided evidence showing that she was harmed. So yes, if the basis for throwing out the injunctive order was that Rosa didn't show she was harmed, and then she provides evidence that shows she was harmed, that would be cause to reconsider. So they're gaslighting again. There's our state the cases. Plaintiff maintains there are 3 facts that she discovered after filing a TRR motion: the deletion of MMTLP, which we'll get to that later, the failure to issue NextBridge shares pursuant to the one-to-one exchange, which has happened, the failure to FINRA's knowledge of outstanding short positions. As with plaintiff's complaint, this newly discovered evidence is vague, unsupported, and conclusionary. It's from your own website. The short positions is from the FINRA website, right? The failure to issue one-to-one is something that's happened since Rosa filed her claim. Remember, she filed on the 14th, was her original injunctive relief, was on the date of issuance. Right? She filed sometime in the afternoon, and then at 4 p.m. in the afternoon, the issuing of the NextBridge shares went out. So, yes, this is new evidence since she filed, because we have not had conclusive settlement for the majority of folks who claim to own these shares. We're 50 days into this, and still most people have not gotten their shares. They've got these weird warrants and placeholders in their place, but they don't have the actual shares they were promised. So yes, that is new since she filed, because she filed hours before the issuance of those things. So here, they're gaslighting again. They're claiming that this doesn't constitute new evidence since she filed. This is literally new evidence since she filed. FINRA douchebag, right? Okay. The deletion of MMTLP. Here's an interesting thing that I just discovered, or just was sent to me right before the show. If you go to the FINRA website, no D1 order deleting the MMTLP ticker has ever been issued by FINRA. They still haven't deleted the ticker yet. It still exists, according to FINRA. So now they haven't done their job. They've not done their regulatory job, which is to delete that ticker as their own corporate action, and as the S1 filing to SEC stated they were supposed to do on December 13th. They still haven't done it. 50 days later, it still exists, man. So, right? More importantly, none of the newly discovered evidence calls into question FINRA's absolute immunity, and thus it does not impact the outcome of the January 9th order. Okay. She does provide evidence and legal precedent that you don't have absolute immunity. You never had absolute immunity. You had immunity from monetary damages. That's it. People can't sue you for money. So you keep saying absolute immunity, but you don't have it. You're making an argument that does not exist. It'd be like saying, it's like the arguments those sovereign citizen dudes do, right? You get pulled over for not having a license plate and driver's license, and the cop's like, driver's license registration. Yeah, I am a sovereign citizen. I am my own country. Therefore, I have diplomatic immunity, and you cannot ask me these questions. I'm not going to answer anything. And the cop just pulls a gun on them and hauls their ass to prison. So they're claiming things that don't exist. All right. Order for this reason alone, the evidence plaintiff identifies as newly discovered does not provide a basis for this court to reconsider. It does. Because newly discovered evidence fails to meet one of the elements outlined in this one case, the court needs not reconsider on any other basis in order to deny the motion. If newly discovered evidence fails to meet any of the 5 elements needed for the evidence to support reconsideration, a motion for the reconsideration should be denied. Again, they're totally gaslighting us. 2. Plaintiff's motion is an improper attempt to re-argue the motion for temporary restraining order. Plaintiff's motion does not point to any manifest errors of law or fact. It does. You claiming that it doesn't does not mean that it doesn't. She pointed out that you cited court cases wrong, and that those court cases said the opposite of what you claimed. She cited other court cases that showed clearly you do not have immunity, therefore it shouldn't have been tossed in the first place. So you're gaslighting us. All right. Okay. Citation quotation marks omitted. All right. What is going on here? I don't know what they're doing here. All right. Argument plaintiff advances to dispute FINRA's legal arguments would not require a different outcome. Even if the court were to reconsider the arguments, plaintiff advances in the motion. So here they are saying that the plaintiff A didn't make any arguments. B, when she did make arguments, they weren't good enough. And C, if they were good enough, then they shouldn't consider them anyway. Those arguments don't provide a basis to reconsider. Further, only some arguments advanced in the motion warrant comment in the opposition. So like, it doesn't even like get to the scale where we can even bother commenting on this. Now remember, earlier they pointed out that she said these short positions weren't closed out. They like, this is what she claimed, and then they never addressed that point. They still have not addressed that point anywhere in here. Rosa said, hey, you halting this meant these short positions weren't closed, and now I can't get my 1 for 1. Right? They haven't addressed that at all. They've never acknowledged that the short position still exists. They just went, silly child, making these claims. That's all they did. Absolute immunity applies to equitable claims. In its opposition, FINRA established that it is absolutely immune. It's not. From suit claims related to regulatory functions, such as imposing the trading halt on the Series A preferred shares. She showed that you put your finger on the scale and you caused more problems than you claim to be stopping. That was what she pointed out, that it was not a normal thing. It was an extremely one-time thing that's only ever happened to this one stock and nothing else. Therefore, it doesn't seem to be a quintessential decision that's quite regular. And they claim that her assertion is inconsistent with federal court decisions that have discovered that they've considered the issue and applied absolute immunity to bar claims in seeking equitable relief. Except she showed literally cases where equitable relief was granted by the court against FINRA. So FINRA keeps saying absolute immunity over and over and over again while ignoring the fact that equitable relief has been made against FINRA in the past by these very courts. Okay, lots of cases they cite here. In this case, there can be no dispute that when FINRA directed its members to halt trading and quoting of the Series A shares pursuant to SEC-approved rule, FINRA was engaged in regulatory functions subject to immunity. Okay. If you made that decision, right, to protect the investors, then why were the investors harmed by that decision? And if that decision happened to only help the short hedge funds who were illegally shorting the stock, then how did stopping trading protect investors as you claimed? Which is what the SEC rule says. The SEC rule says they can do this if they're protecting investors, but they harmed us. And that's what Rosa is arguing, that their decision harmed investors and therefore was not under the purview granted to them by Congress and under the provisions from the SEC to halt trading. So, All right. Plaintiff allegations of irreparable harm remain speculative. Plaintiff's attempt to cure her failure to allege irreparable harm in the complaint of the TRR motion is equally unavailing. In its opposition, FINRA established the plaintiff failed to allege any injury, much less actual imminent harm. Except she did repeatedly. You're just gaslighting us again. Like plaintiff's initial attempt, the motion makes conclusionary or speculative allegations of imminent harm. Why don't you perhaps talk about what those allegations of harm are and address them specifically, rather than just doing this like vague, hand wavy, she didn't actually do this. Shareholders, including plaintiff, face loss by either a dilution of their next bridge interests, which is happening right now, or a total loss because they have not received NextBridge shares, which is also happening right now. The imminent harm to plaintiff and shareholders alike is either the total loss of any rights to assets, MMTLP or NextBridge, or the dilution of NextBridge shares, both remedies harming plaintiff, which is true. These conclusionary allegations of imminent harm are insufficient as a matter of law to support the request for preliminary injunctive relief. Okay. They filed this 2 days after an S1 to dilute the float was made by the company. So therefore, if it was speculative, it was fucking accurate. Right? So here, they're claiming it was just speculative, Your Honor. When it happened, it literally happened. The thing she said could potentially happen that would harm her happened. Oh, we got a regular Nostradamus on our hands here. Okay. Okay. And they don't actually address the people aren't getting their shares thing. So, remember, they halted because they said settlement would be a problem if people got 2 more days of trading. They wouldn't be able to settle, and therefore they wouldn't get their shares. And here we are 50 days later, and people still aren't getting their shares. Okay. Moreover, plaintiff's argument that any purported harm could be mitigated by requiring FINRA to reinstate the original MMTLP QSIP until reconciliation can be verified demonstrates a fundamental misunderstanding of the Meta company action and the scope of FINRA's regulatory authority. Importantly, FINRA understands that Meta already canceled Series A shares that it issued, which were previously traded in the OTC market. They didn't. It was FINRA's job to do that part. Under the symbol MMTLP. Thus, there is nothing that FINRA can reinstate. FINRA still hasn't deleted the ticker. They can turn it back on anytime they want. Why? Because they have not issued the D1 order that deletes the MMTLP ticker. Right here, they just lied to the court. FINRA does not assign QSIPs to securities, and Securities A shares that were traded under MMTLP symbol no longer exist because they were canceled by Meta. They still exist. Mainly because everyone has one in their account still because they don't have the real deal. Okay. The mere existence of MMTLP symbol would not result in Meta reissuing the Series A shares. It has nothing to do with Meta reissuing. It has to do with you closing the short positions, right? FINRA has no authority to require a company to reissue securities. They're not asking you to reissue them. They're asking for you to turn it back on so they can close their positions. You wouldn't be trading the real deal. You'd probably just be trading a bunch of fake shares that never existed in the first place, right? That's the whole point of these naked short shares existing. Plaintiff therefore fails to establish any actual imminent harm. If they haven't gotten their NextBridge shares yet, then they've been harmed. And your action resulted in them not getting their NextBridge shares, which constitutes who harmed them? You, right? Plaintiff therefore fails to establish any actual imminent harm. Moreover, as discussed in FINRA's motion to dismiss, the complaint does not allege any concrete or personalized injury to support Article 3 standing. As a result, this court lacks subject matter jurisdiction to consider plaintiff's claims. Okay, here they're saying you can't even take us to this court. This court is monkey business, and therefore, Judge, you're a pissant and you shouldn't even be looking at this. She stated a fear that the stock would be diluted and she wouldn't have the opportunity to get out. And the stock was diluted and she doesn't have the opportunity to get out. 2, she stated that FINRA's actions would resulted in bad settlement of the Nextbridge shares, which it has. And they're gaslighting the judge, saying that none of those things happened. 3, plaintiff's complaints regarding FINRA's exercise of its regulatory authority do not give rise to private right of action. Finally, plaintiff makes a number of arguments criticizing how FINRA's exercises regulatory authority. FINRA's consistent actions through the life of MMTLP have demonstrated actions in concert with brokers and market makers to alleviate the obligations of reconciling short positions and naked short positions, which violate securities law. Alleging the accounting would reveal whether FINRA regulated bad actors. FINRA's justification imposing the halt is erroneous, and the timeline of events has consistently demonstrated a lack of regulation. In an effort to address FINRA's purported failures, plaintiff argues judicial intervention is available because there must be a mechanism to check on those acts of SROs and to ensure the self-regulatory conduct is done in good faith. Plaintiff's argument ignores that under the comprehensive regulatory scheme for the securities industry that was established by Congress, FINRA's performance of its responsibilities is subject to the strict ongoing oversight of the SEC. Basically, right here, this is really crazy, is that FINRA admits to fucking up. I don't know if you guys saw it, but Rosa points out that FINRA did a bad thing. And FINRA did a bad thing repeatedly in concert with brokers, market makers, etc. Right? Such as when FINRA allowed the stock to trade on falsified and forged data. Right? It wasn't supposed to trade, and FINRA let it trade because GTS said, "Oh, we're gonna make it trade," and FINRA's like, "Whatever," and they completely ignored all the rules and regulations required by their own rules and by the SEC to allow this to happen. And then when the complaint was made by Metamaterial to FINRA went, "Oh, too late," right? So in this, they're saying, well, the SEC is supposed to do something about that. SEC is supposed to make sure we don't do those things. So basically they're saying we broke the law, but it was the SEC who was supposed to make sure we didn't break the law, right? They basically admitted their own crime right here. Okay. Thus, Congress has vested in the SEC the obligation of ensuring that FINRA performs its statutory responsibilities. In doing so, Congress not only declined to create an express private cause of action against SROs, but also created an alternative method of enforcement by relying primarily on the SEC. Primarily, not entirely, right? Okay. So they admit to breaking the law and not regulating according to the best practices, but by putting their thumb on the scale and favoring their buddies, right? But then they say, well, we broke the law, but it's the SEC's job to reprimand us, not the courts. That's what they're saying. Basically just admitted to committing all the crimes. All right. For these reasons, and those discussed in FINRA's motion to dismiss, the remainder of plaintiff's arguments need to be addressed in order to establish the motion must be denied, or need not be addressed. Basically saying, you don't have to look at this because we have immunity and fuck you. Conclusion, for the reasons stated herein, FINRA requests the plaintiff's motion for consideration be denied. Okay. David S. Mendel. All right.